Good morning. Chapter 36 has got some importance to understand because there are certain provisions which restricts filing charge sheet beyond a certain period. Probably the young lawyers used to misunderstand between 167 class 2 which prescribe a period of limitation for offences punishable below 10 years and about 10 years. 60 days and 90 days. That is only in respect of restriction of period of remand. Therefore, filing charge sheet after that period, if the accused is released on bail, will have no impact. But filing final report, this chapter 36 deals with limitation of taking cognizance of certain offences. It runs from sections 467 to 473. The limitation of period is as follows: 6 months if the offence is punishable only with fine. 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. 3 years if the offence is punishable for a term exceeding 1 year and not exceeding 3 years. So it impliedly you have to understand that if the punishment is not if it exceeds 3 years, there is no limitation at all. That you have to impliedly understand that if the offence or charges are within 3 years, then the only question 468 applies. So kindly then the commencement of period of limitation 469 on the date of offence where the commission of offence was not known to the person aggrieved by the offence or to a police officer, the first day on which such offence comes to the knowledge of such person or to any police officer, whichever is earlier. Then where it is known by whom the offence was committed, the first day on which the identity of the offender is known to the person aggrieved by the offence or to the police making investigation to the offence, whichever is earlier. So this is the number 1 date of offence, number 2 knowledge of offence, number 3 identification of the offender. These 10 date of commencement occurs. Then the exclusion of time in certain cases. For computing period of limitation, the time during which the person has been prosecuting with due diligence another prosecution, whether in a first court instance or in a court of appeal, revision against offender shall be excluded. So this limitation is applicable in civil cases also. If you wrongly approaches the court, that period of approaching the wrong court may be excluded. Then there is a stay injunction is there, then that's also when sanction is necessary, then the period of for obtaining consent shall be excluded. That period of sanction must be from date of application, and obtaining the consent should be alone excluded. The offender, if absent from India or any territory outside India, or been arrested, or been avoided arrest, or absconding or concealment, shall be excluded. So this section 170 class 4 may be exploited or extended or misused or used. Then date of court closure or holiday may be excluded. For continuing offence, fresh period of limitation shall begin to run at every moment of time during which the offence continues. These all are then the question very important. 473. The court may take cognizance of offence by accepting the delay in filing the final report after the period of limitation by explaining the delay properly. So this is most important. Here a case is there, you can understand that the entire chapter 36 regarding limitations. The sections are 109, 341 and 506 part 1 IPC. They say since the period of limitation is 3 years and the charge sheet since filed after 3 years, so the taking final report was quashed. The other side has stated since it has been taken on file, the lower court ought to have exercised 473 CRPC for condonation of delay or extension of time for limitation. But the Honorable Tamil Nadu High Court Madras held that where is the proof, who has satisfied whom, where is the material, therefore they caused it. Rajasekhar vs State 2022 2 MLJ Criminal 396 Madras. Rajasekhar vs State 2022 2 MLJ Criminal 396 Madras. I hope you understand very important provisions.